still working on sound, but we're almost there. So she said live streaming's going.
So she just turned up the volume, trying to tell her to turn it down because she's working on sound.
I'm not sure.
Amplifier on? Something is strange.
Okay.
Thank you for the nice folder.
Thank you for being here. Thank you for being here.
My name is John Echevarria. I'm a professor here at Vermont Law School, and welcome to Vermont, and welcome to Vermont Law School, and welcome to this symposium sponsored by the Vermont Journal of Environmental Law. And as a point of personal privilege, a special welcome to my cousin Hugo Echevarria from Ecuador. It's always great to see a fellow Basque. I am the faculty advisor to VJEL, which is extraordinarily light duty because Vermont Law School students are very independent and self-reliant, and that is especially true of the VJEL editors, so they very seldom ask my advice. My only real responsibility is to speak for 3 minutes every year at this conference. In addition to the symposium, of course, the VJEL publishes the Vermont Journal of Environmental Law, one of the nation's leading environmental journals. Importantly, a completely online journal. So if you publish with VJEL, unlike with some other journals, you don't have to suffer the guilt when 4 months later some unexpected box comes with a large volume of paper copies of the article you produced that you don't really need because it's always available online. So VJEL walks the walk when it comes to environmental sustainability. In addition to publishing the journal, VJEL produced the Eco Perspectives blog, which you'll see on the VJEL website, which has lots of interesting commentary on contemporary environmental issues. In addition, annually produces the top 10 environmental watch list. One of the perils of working in the field of environmental law and natural resources law and energy law and this great big large sprawling field is there's so much going on and it's very hard to keep track of it. And so what VJEL in conjunction with the environmental faculty does each year is to sit down and try to think about the last year and say what was important about the last year and let's try to synthesize a statement of what has happened over the last year that people should be paying attention to and what is the forward projection of those very important issues. And that will be coming out towards the end of the year. Finally, I'm just delighted that we're focusing on the topic of rights of nature. Those of us who've toiled in the environmental vineyards for years and years are facing increasing frustration that our highly sophisticated, technocratic, carefully calculated cost-benefit analysis with all the various figures discounted to the present are not exactly producing positive results. And whether you're dealing with climate change or loss of species and natural resources, a return to a basic assertion basic human values, as well as the values of nature itself, seems necessary. Jedediah Purdy has written about the importance in the climate arena of trying to capture the importance of our debt to future generations by framing the climate issue as a moral issue, and so too more broadly about rights of nature. As Ali Hauk has written, rights of nature tap into a place that anthropomorphism and its pragmatism, for all their importance, cannot touch, a powerful link to the human heart. So I, for one, am looking forward to today, and I'm sure all of you are as well. And I turn matters over to Dylan Post, the editor-in-chief of the Vermont Journal of Environmental Law.
Well, thank you, John, for that excellent introduction. And I am so excited to be here today, not only because of who the different speakers are that we have here today, but as well the interesting topic, as John outlined. It's one that personally excites me, and I think excites the entire journal and this law school as a whole, and is gaining ground in the environmental movement and community. First, I'd like to say a couple thank yous. I'd like to thank the speakers for coming today. They've traveled far and wide from all different areas of the country, and just to come and talk here for us and to help expand this body of information on rights of nature. So thank you. Second, I cannot go any further without thanking Margaret and Hannah, our symposium editors. They've made our lives very easy in both setting up this symposium, coming up with the topic, which I'm going to dive into a little bit more in a minute, and also with crafting such an excellent panels, excellent speakers, and having everything come together in a way that's going to hopefully and will help bring a true forum of environmental tenure into what we're doing here today with rights of nature. Third, while John might have made it seem like the VLS faculty doesn't help the Vermont Journal of Environmental Law too much, they certainly do, and so we'd like to thank them. Fourth, the VLS staff, just generally, we would not have all this wonderful accoutrements today. And last, and equally important, the VJEL staff, and especially the symposium committee. So thank you all for helping this day come together. So as many of you may know, and many may not, this is actually the 20th anniversary of VJEL. So we're excited to have such an interesting topic based on rights of nature, for our 20th symposium. Now, just to get into a minute about how proposals are selected for the symposium. So it goes through a process where students go ahead and propose a different topic for us to do this year. And this year, Margaret and Hannah proposed rights of nature. And personally, I had heard about it before, and I knew some about the movement, but had not quite gotten the full depth up until Margaret and Hannah's presentation. And they presented the topic in such an excellent way, and that it represented how important it is to the field of environmental law and how forward-thinking this topic is, which is why I think everyone on the Vermont Journal of Environmental Law and probably Vermont Law School as a whole is very excited to have this topic for the symposium today. It's especially important for VJEL because, first off, it focuses on a new, fundamentally different thought process focused in environmental law. And second, I think some of the dialogue today is going to focus on what other nations actually do and how can we apply that type of thinking to our own system here in the U.S. And I'm going to keep this brief, so I only have two final points to conclude. The discussion today is going to talk about the access to the judicial system and inherent rights to fundamental important issues in all areas of law, and especially environmental law. So please continue to ask questions today, in the future, as well keep the conversation going. Think about rights of nature. Discuss what you learn here and see here today with your friends and other colleagues, and think about this body of law and how we can continue it and how it interrelates with our own area of practice. So thank you. And I'm going to turn this over to Margaret and Hannah, our wonderful symposium editors.
Okay, first, a few housekeeping rules. Oh, and hi, Cormac. It's good to see you. If you ask a question, we ask that you please use a microphone so that the people on live streaming can hear you. I know a lot of folks here are great at projecting their voice, but we can't get it quite through the internet without the use of a microphone. So there will be 2 roving mics with students here. Just raise your hand and they'll come over and give you one for making your comment or your question. If you are watching on live stream, we will take questions and comments over Twitter. Our handle is at VJEL, so that's at VJEL, and you can tweet us. We'll choose a few. We won't probably be able to get to all of them, but we'd be happy for you to participate wherever you are in the world. We also have social media placards hanging around the room. You'll see them. There's some on the Huli Mwetchits in the middle. And around the room, and please feel free to follow us, tag us in your posts. We also have a photographer in the breezeway, and he is taking photos in front of a very beautiful tapestry, and we'd love for you to have your photo taken there, and please tag us wherever you post that. If you have a pink tag on your name, or a pink dot on your name tag, you've registered in time for lunch. If you do not have a pink dot, we encourage you to purchase something delicious from the cafe right outside of these doors here and come join us for our lunchtime activity. Also, there are recycling bins over here in the corner, should you need them. So my name is Margaret Shugart. I'm a third-year law student here at Vermont Law School and one of the editors for this year's symposium. I'm interested in where the law is headed. I came to law school to be part of its change, and I came to this school because it recognizes the power of the tool of the law to make the world a better place. The idea behind the rights of nature is not new. I personally believe it is inherent in our animal selves, and that every animal has remembered it except us. I was bolstered by attending the Rights of Nature conference organized by the Community Environmental Legal Defense Fund at Tulane last year. As one professor and a respected environmental practitioner said, it hit him one day as he was standing outside, and he saw a bird fly overhead, and he thought to himself, that bird has a right to be here. And as one of the speakers on the Indigenous Perspectives panel logically explained, we breathe in air that becomes part of our bodies, and yet in the law we call that air an externality. It is the same with water. There's something missing in our current legal approach. Although these conversations about nature's inherent rights were taking place in the 1970s, we veered into human-centered laws like the Clean Air Act and the Clean Water Act. They did wonders to address dire pollution issues. But as some speakers will address today, and as John alluded to earlier, there are shortcomings to these laws, and we're also seeing them being dismantled. So is there another paradigm to take their place? And is it this? Is it giving legal personhood to natural entities? Even though I feel its rightness, I still don't know its place in the law. So that's why I'm eager for today's discussion. I hope to untangle the hang-ups in my own mind, and I'm hoping to hear others' bright minds work through the complexities of standing, of guardianship, and of the role of responsibility in granting rights, as we do as humans. I hope that we take a step forward today and turn ever so slightly so that we see this world a little differently when we leave the room. My partner and I were blessed to welcome our daughter, Sylvan Kit, which means baby fox of the forest, here this June. It's cliche to say, but oh so true, that she's inheriting this world. We hope to introduce her to nature so that she sees herself as woven within it, and I personally hope that we can move the law towards something that feels the same.
Hi everyone, my name is Hannah Dean and I'm a third-year law student and one of the symposium editors for volume 20 of the Vermont Journal of Environmental Law. Current models of environmental law are still centered around humans, and for many individuals, including myself, this is bothersome. We are well into the period of the Anthropocene, and we are seeing now, more than ever, humans' negative impacts on the world. I can't help but feel as though many environmental laws do not truly achieve the best results for natural entities, despite good intentions. Instead, our legal system may need to consider a shift to a model that does seek Earth's best interests. As a law school that has a comprehensive environmental law program, we want to be sure that we remain at the cutting edge of new legal theory. Rights of nature is a logical extension from our current environmental curriculum. The issues that many attorneys are fighting for and the issues that we are considering today are in a similar vein to current models of environmental law, but looking at them through a different lens. As Margaret said, this approach is not new, but its application to the American legal system still needs some thoughtful consideration, and we hope to take part in that here today. Personally, animal law is what first piqued my interest in this topic. After looking at some of the arguments made on behalf of animals and their potential for legal personhood, I started to wonder if this could happen for other natural entities as well. During the summer of my 1L year, I took Cormac Cullinan's course, Earth Law, and I just was instantly interested. The course was inspiring, to say the least, and I knew that rights of nature had to be something that was at the forefront of my vision with environmental law. Shortly after that, Margaret and I met together for the first time about a year ago today to discuss brainstorming a rights of nature symposium for the law school. Our environment's changing, and we need to consider how our legal system is going to address those changes. Today, we're excited to have a meaningful discussion to consider whether rights of nature may be part of that answer. As Daniel Quinn eloquently said in his novel Ishmael, "You are captives of a civilizational system that more or less compels you to go on destroying the world in order to live. I think there are many among you who would be glad to release the world from captivity, but this is what prevents them. They are unable to find the bars of the cage." Thank you so much, and enjoy the symposium.
So as Margaret is dialing us in, let me make a few comments. First, I want to start by expressing my gratitude for Hannah and Margaret, who've assembled an extraordinary faculty here and have demonstrated this commitment to heal the world. I want to give gratitude as well to Thomas Berry, really one of the thought leaders, early thought leaders in this expression of our efforts to change law in a way that will, again, heal the world. And of course, I want to express my gratitude for the opportunity to speak to you, and I expect to be heard, to do what I can to heal the world. And in my tribe, there's a term, it's tikkun olam, and that's an Old Testament term that, again, strikes at the heart of what we seek to do as lawyers, as movement leaders. We want to heal the world. So we're going to start because I want to see who, like me, is excited and energized and passionate and driven by the fact that we, humankind, are probably closer to extinction from this planet than our origin. It's one way of looking at things, and we can be frightened by it or we can be enthused by it, and I think that I know the people on my panel are enthused by this opportunity, and so we'll start with some presentations by each of them just to give you all some orientation as to where they're coming from, what their experiences are, how they think about this certainly surmountable problem that we're all facing. And Cormac, who's disappeared from the screen, but I expect can still be heard. Can you be heard, Cormac?
And we'll put him on it when he's up.
He's going to go first.
He's going forward.
He has to go first, but it's up to you. Cormac, it's not me, it's Margaret.
Okay, you can see but not hear.
Can you hear? Raise your hand if you can hear.
No?
Can you hear me now?
Yes.
Okay.
All right.
Great.
There you go.
Shall I just
Sorry
start?
about the curveball. He called me yesterday.
Oh,
I didn't tell you.
know. Okay.
All right, kick it off, Cormac.
Okay, good. Thank you. Well, hello, everybody. I can't see you, but I can hear you, which is good. So I'm sorry I'm not there in person because I'd very much like to be. But I've been asked to just quickly kick off with a few, explaining a few of the general terms, really as an introduction to the subject, and then we can get into the more interesting parts of it when we have the question and answer session. So with the very recent report of the International IPCC report on climate change, it's very clear how very important these discussions are. We need to make very, very fundamental changes in human society very quickly if we're going to deal with climate change. And I believe that climate change itself is not the problem. Climate change is one of many symptoms of a deeper systemic problem. And law is, of course, one of the most important structuring elements of human society and also the basis of the economic system, etc. So one of the reasons why our system is producing symptoms like climate change, dramatic loss of biodiversity, etc., is because our legal systems are designed to legitimize and facilitate the exploitation of Earth. In other words, what's often referred to as extractivism, the idea that human well-being is best achieved by taking as much as possible from nature as quickly as possible. So to get into the terms we're talking about, so this is a conference about shifting paradigms and groundings in law. But what is the paradigm that we're talking about shifting? Very briefly, I think it's a shift from an anthropocentric paradigm which sees human beings as separate from and superior to nature and the arbiters of all value and meaning. In other words, something is valuable or worthwhile if we say it is, if it's useful to us, otherwise it has no value. Now, I believe that most of the legal systems in the world are based on a worldview that dates back to the 16th and 17th century age of enlightenment in Europe, when they basically understood the universe as a kind of mechanism, like a giant clock or something like that. And the idea was that we could learn exactly how each of the cogs worked. We could manipulate the global system for our advantage. But as Thomas Berry said, the world is not a collection of objects, it's a communion of subjects. In other words, it's a living community in which each part or each aspect or each member of the community is interrelated and interdependent with the other members of the community. So if the world was indeed a mechanism, our legal systems would make sense, where they define only human beings and corporations as holders of rights, and everything else as property, which is owned by those legal subjects and which has no inherent rights of its own. So that would make sense if we were talking about cogs, but of course the sciences long ago abandoned the mechanistic understanding of the world because it's simply inaccurate. So part of the shift that has been called upon to make is, in a way, also a return to a more ancient way of understanding ourselves as being part of an integral part of a larger and more magnificent whole, which in this case we call Earth. So that has implications for the law, because most law is designed to regulate relationships between humans with a view to having more effective, more stable human communities. In other words, laws prohibit activities which are antisocial, and antisocial is defined in relation to what is good for the human community as a whole. But if we are now recognizing that we're part of a much larger Earth community, it means that our concept of what's antisocial needs to shift, and laws need to be aimed at regulating and ensuring behavior which is beneficial to the community at large, in other words, the whole Earth community. But another thing which is often overlooked in these discussions is the word law, because for most of us, particularly those of us who legally trained in systems which originated in Europe primarily, law is primarily means text. It means legislation, it means judgments, and it means what academics have written about them. And as various writers have pointed out, law in this sense tends to be an elite top-down the process of making law. What is law often reflects who is the most powerful in society, who's got the power to lobby the lawmakers, etc. But there are other forms of law. So customary law, for example, that you find with indigenous people all over the world is a very different kind of law. It's typically not written down, it's typically oral, it's bottom up, it's essentially reflects the changing norms and understandings of those communities as what constitutes acceptable behavior. And so it's created by processes and it changes over time. But it is law in the sense that it reflects the community's idea of how members of that community must behave. So to give you an example, the hashtag #MeToo movement has recently, I think, dramatically shifted global norms of acceptable behavior, for example, in the workplace. So that may not yet be in law, but effectively it's becoming, you're seeing a shift in social norms which will be reflected in law if they are not already reflected in law. But one of the implications also of this approach that we're talking about is that, as again citing Thomas Berry, he referred to the fact that the universe becomes the primary lawgiver. In other words, we are now accepting that we are born into an ordered universe, and that if we are to flourish within that universe, it makes sense we ought to adapt our behavior to how the system as a whole works. So in trying to define what that meant, I used the term great jurisprudence to mean essentially that not just the rules of nature, but also an understanding of how nature functions, if you like, the accumulated wisdom or complexity of natural systems, but something which is not generated by humans. So in other words, indigenous people often refer to receiving the original instructions, that some mythical ancestor was told the rules of how the system works, and those rules typically center on maintaining maintaining respectful relationships with other beings. So customary law, indigenous law, is very oriented throughout the world to maintaining good relations, not just with other human beings, but also with the mountains and the rivers and the forests, etc. So in that sense, law, our concept of law is also, we talk about the expanded concept of law. So if we accept the great jurisprudence as a term for essentially what is given, what is beyond our control, the laws that we must fit in with or adapt to, then a human philosophy of law that does so, I would call it earth jurisprudence. And in fact, we need earth jurisprudences, plural, because philosophies of law will vary according to different cultures and according to different environmental conditions. So earth jurisprudences would be philosophies of law, essentially ecocentric philosophies of law, which are designed to guide humans to be good citizens, if you like, of the wider community of life, rather than to just good citizens vis-a-vis other humans, or to dominate and control and manage the system, which is one of the primary purposes of the current system. So although one can express this in moral terms, I think I often just express it in terms of adaptation. It serves the human purpose for our self-regulatory systems to be highly adapted to the larger system of which they form part. And then moving to the question of rights. Now, as we know, rights, the concept of rights is a construct which only some cultures have. Many indigenous cultures don't even have a word for rights. And it's a construct that we've come up with so that we can use the courts and the mechanisms of the state to protect and enforce certain relationships that we think are important. And a later development is the concept of human rights. Now, human rights are a little bit different because we say that human rights are inherent and intrinsic. In other words, even if your legislature of your country denies that you have these rights, or the courts of your country deny it, we say that they cannot be taken away from you because they're inherent and intrinsic. Now, this, in essence, flows through into the concept of the rights of nature, because if we say that you have rights, human rights, fundamental rights, which are inalienable merely because you exist as a human being, then that same argument applies to everything, all beings. As Leonardo Boff said, that which has come into being has the right to be. In other words, the idea is that if you have succeeded in surviving the long evolutionary process and you're now an integral part of this community of life, you have the right to continue to exist and play your role within that community of life. So the argument essentially of rights of nature is that all aspects of the whole have inherent inalienable rights, and these exist regardless of whether there's legislation recognizing them or not. In other words, they already exist in every country in the world, and that is why we refer to the recognition of the rights of nature rather than granting the rights of nature. They already exist. It's just a question of whether your legal system recognizes them or not. They can also be this can also be understood as an imperfect translation of Indigenous peoples' worldview. Although they may not use the term rights, they certainly recognize that there are other beings and that they are entitled to their place within the community of life and entitled to respect. And that means that anything which, from this perspective, anything which violates these fundamental rights is effectively unlawful in a fundamental sense, in the same way as a violation of human rights would be regarded as unlawful, even though, as we know, it often goes unpunished. So then, what do we call actual laws, whether they're written laws or oral unwritten laws, which reflect this ecocentric understanding of Earth jurisprudence? I used the term wild law to reflect the fact that they ought to be laws which work with nature and encourage the flow of the creative energy which has brought the universe into being. But other people use the term earth laws or other such terms. But I think the central concept is that you have, first of all, the inherent ordering of the universe. It's called great jurisprudence. You have human philosophies of law based on that, earth jurisprudences, and then you have laws which reflect and give effect to those philosophies or understandings, which you could call wild laws or earth laws or other terms. But I'm going to stop there and let everybody else add their contributions, and I look forward to the discussion. Thank you.
Thank you, Cormac. We'll turn to Grant next, I think. No? Again, my moderation skills are pretty weak so far.
Yeah, I can go. Yes. Yeah.
Right now. Okay, yeah. Margaret will go.
All right then, Margaret, you're up.
Okay.
And I'm going to set up her PowerPoint quickly. We just have to.
Okay, so I need to,
We need to be able to see.
screen them. Shoot, that's messing it up.
We can get started, and then if
Why don't we,
it's not.
move past this awkward silence and
So good morning, and thank you so much for having me here today, and thank you to the organizers specifically for putting me on this panel. I'm the type of person who I like to do my presentation first so that there's nothing to compare you to. Thank you. I was always the one to shoot my hand up right away at school, so I appreciate that. But then the joke's on me because now I'm following Cormac, so we'll see. Life's about balance. This will go good. So as Tony said, my name is Margaret Stewart, and I am the director at the Center for Earth Jurisprudence, located at Barry University School of Law. And at the center, we advocate for more Earth-centered laws and policies that recognize our interdependent relationship with the entire Earth community. We follow the teachings of Thomas Barry, who very poignantly said, "We invented the concept of rights and then gave them all to ourselves." Right? So we work to recognize that mutually enhancing relationship with our entire Earth community and then codify that in our laws. Because as lawyers, we think that the best way to accomplish this is through the law. Because really, what are laws but reflections of our priorities and regulators of human behavior? So we just think that's the best way to accomplish this recognition of our mutually enhancing relationship with the Earth community. So I wanted to take just a few minutes today to kind of go through the underlying philosophy behind Earth jurisprudence and what this paradigm shift we're seeking is based on. So throughout the day today, we're going to hear from some really amazing people from around the world who are going to really dissect these important legal concepts for us. So I just wanted to kind of give us an underlying basis for that discussion that we're going to be having through the rest of the day. So our mission at the Center for Earth Jurisprudence is to advance law, policy, and governance systems aimed to legally protect the sustainability of life and health on Earth. And as our founder and our current Director Emeritus, Sister Patricia Seaman, perfectly put it, our work is based upon the concept that humanity has a basic responsibility to care for and protect the long-term health and well-being of the entire Earth community, meaning all beings and ecosystems that constitute the natural world. So how do we accomplish this? Well, first it's important to recognize what is missing from our current regulatory environmental law system to determine what we need to fix, right? We like to say that Earth jurisprudence is this missing piece, but what are those missing pieces? So it's just a very simple breakdown in front of you now, that the main issue with our current body of law is that they're inherently anthropocentric, meaning that they take that more human-centered perspective. So what's the problem with this? Well, we need to care for and protect ourselves, right? There needs to be some sort of self-preservation involved here. But the problem is that we're only part of a vast, interconnected Earth community that also deserves consideration and legal protection, and this is not currently the case. Our system is really based on traditional property law concepts that commodifies and basically exploits the rest of the Earth community for our own benefit. And we're seeing that not only is there a moral quandary with this, but a sustainability one as well. The idea that we can have this economic system based on the exploitation of the rest of the Earth community is really an illusion, and it's one that's falling apart before our very eyes. We're seeing the destructive effects of our current policies all around us every day. So what's the solution? Well, at the center, we strive to shift our cultural paradigms and understandings from this current human-centered approach to include the interests of the larger ecological community as well. And we do this in a variety of ways. Such a large paradigm shift really requires attention from both the cultural and the legal approaches at the local, national, and international level. So it's a big undertaking. We really have to shift our understanding of what the public good is and accept that if it doesn't include the well-being of the entire Earth community that sustains life overall, that it's really not legitimate and it can't really be considered the public good. One of my favorite quotes comes from lawyer and founder of Nature's Rights, Mumte Ito's TED Talk, where she said, "How can we say that we have a right to life when that which sustains us does not have a corresponding right to life?" Right? I mean, it just makes sense when we think about it. So when we take this more holistic approach to our legal considerations, we can see how adopting these principles will start filling in those holes in the system that we currently have. So now I know for some people who are not, gung-ho and advocates of this particular area of law, there's some questions popping up in your head as we're going through here. Does this mean that I can't even swat a mosquito if it's got the same type of right? So can I not kick pebbles around? How far does this go and how does this work? Well, that's where the necessity of rethinking our whole idea of what rights are comes into place. Yeah, I'm on the right slide. So we tend to look at things, through a silo, hence the basis for a lot of our problems that we're seeing with our interactions with the rest of the Earth community. We have this very narrow idea of what rights are, and we look at them through this understanding of what human rights are. But as Thomas Berry said, you wouldn't give a tree human rights. A tree has no use for human rights. A tree has tree rights. Rivers have river rights. And so what we need to do is to expand our understanding of what rights are before we can adequately recognize them in the non-human members of our Earth community. Because again, our whole understanding of what rights are and how they work is based in our own anthropocentric view. So it's about expanding our understanding of that. And this is why we rely so heavily on the wisdom of our indigenous relatives, because basically what we're trying to do here is get back to a place that they've never left. We're trying to reestablish this relationship with the Earth community that they've really always maintained. So we look to them and to their wisdoms for guidance to increase our own understanding, as opposed to starting from scratch and trying to figure out this unique concept that isn't really built into our system. So what does this practically look like? Well, we have many wonderful examples from around the world, and I'm not really going to take too much time to go into them because today we have experts from all over the world who are going to do that for us and really dissect these examples for us. But I just wanted to give you sort of an idea that since the ratification of the rights of nature in the Ecuadorian Constitution in 2008, at least 7 countries and dozens of communities in the United States have recognized this inherent right and legal standing for nature in their legal systems. We've seen the tools that we already have at our disposal being used in ways that take a more Earth-centered approach as opposed to the current human-centered one. We've seen precautionary principles added to existing laws. We've seen communities take back their rights, even as human communities, to care for their common home. We've seen the expansion of our understanding of the public trust. We've seen the general acceptance that all members of the Earth community have the same inherent rights we do. We've seen guardianship tools being used. So it's definitely something that is possible. It's not a completely new system that we need to undertake. There's ways that we can alter our current systems to accomplish these recognitions that are so important. So what do we do going forward? Is this a huge undertaking? Yes. Is it a complete rejection of our understanding of rights and property and everything else that we've based our entire society on? Yes. Is it doable? Absolutely. We have changed our systemic way of thinking before, many, many times over the course of our existence. When I was a child, I did not have a computer hooked up to the internet. Yesterday, driving up here, the little computer in my hand, the network was running slow, and I honestly didn't know what to do with myself. So, things change, and it wasn't even not working, it was just slow, And so, things change, we evolve as our understandings change, our technologies increase, There's ways, that we can do that. And the good thing about this is that it's not really a change. It's just getting us back to where we began and to a place that we never should have left to begin with. So I'm personally really looking forward to hearing from everyone else today about more ways that we can do that. So thank you very much.
I'm not going to pretend to know who's going to go next, but I do want to make one follow-up remark about what Margaret explained, paraphrasing Thomas Berry, that humans have human rights, rivers have river rights, insects have insect rights. And that's something that's difficult to understand. It's very difficult to conceptualize. How can we know? But I find it easier to think about responsibilities. We have human responsibilities. Rivers have river responsibilities to the fish, to the wildlife, to the farmers, to the indigenous people as perhaps a sacred place. And if we look at then the law as a matter of balancing responsibilities. And we succeed, and rivers have legal standing. I think we will solve problems effectively by considering not the river's rights as much as its responsibilities, and how can a river serve those responsibilities that are often conflicting based on other rights, on humans' rights, on the rights of farmers, on the rights of the animals in the ecosystem. So I throw that out as just a template for further discussion.
All right. Thank you, everyone. My name is Grant Wilson. I'm the directing attorney at Earth Law Center. We're a nonprofit advocacy group that seeks legal rights for nature and law all over the world. Thank you, everyone, for having me today. I've been doing environmental law about 10 years and rights of nature work about 5 years. Just to review the basic tenets of rights of nature, because I know we're doing an intro panel and want to make sure you have a good foundation for the rest of the day. From my perspective, the basic tenets are nature has legal rights. It's recognized as a legal entity. 2, nature has standing in a court of law. Nature actually fights for its rights in a courtroom, which I think is a really amazing idea. That's happening right now in Ecuador, where there's frequent rights of nature cases with nature as the plaintiff. And 3, appropriate human guardians are appointed to represent nature, lawyers, people in this room in the future, I hope. Quickly, does our legal system work for nature right now? If so, what are we talking about? And I would say no. Nature is defined as property under the law, and when something's defined as property, typically it goes to the highest bidder, oftentimes corporations who exploit nature for profit. Exploitation of nature is encouraged under the law. Where I live in Colorado, it's typically illegal for a town to say no to fracking, for example. And in California, you are required to use water, otherwise you lose your right to use it. And the economic system treats environmental protections as a cost and environmental exploitation as a benefit. So that's what we're working up against. Now, what about for rivers? That's what I want to talk about particularly. Rivers, water, the essence of all life, is under the law property. Is owned by humans and corporations. And how much water do rivers themselves own in the United States? And the answer is not a single drop. It's all owned by humans and corporations. River protections, of which there are some, and I'm very thankful for. I love the Clean Water Act. I've said it before, I would marry the Clean Water Act. But these protections are easily reversible and don't go far enough. And the result is that our species teeter on the brink of total collapse. And that's how our environmental policies work. What's been the overall impact? How do we know what I'm saying is true? Well, the proof is in the pudding. We see 50,000 large dams across the world, and these impact 2/3 of rivers. Some rivers, like the Colorado River, I live in Colorado, it has over 100 dams. It no longer reaches the ocean, and this is true of a lot of rivers. And we've lost 81% of freshwater species in the last 42 years. Can you imagine if that many humans died, what a crisis it would be, and how comparatively little we're talking about it? Just to show you an example, Colorado River then and now. Colorado River Delta was once 2,000 square miles in size. There it is now. The Colorado River rarely reaches the ocean anymore. And this isn't the United States. This is a problem all over the world. This is a river that's subject to a lawsuit we're involved in. There it is, completely dry. And when it goes dry, people desperately try to scoop up this endangered fish, the Santa Ana sucker, and put it into buckets with the hope that it doesn't go extinct. This is the Atoyac River in Mexico, another one we're working with. It's the second most polluted river in Mexico. Over 100 chemical facilities dump right into the river. 80% of sewage in developing countries and over 70% of industrial waste is dumped directly into rivers. This is one river we hope to restore by giving it rights. And does anyone here think that these impacts are unique to nature and that they don't impact humans as well? And no. 3 out of 10 people lack clean water at home. We see threats to humans from disease, drought, water shortages, and these problems are getting worse. Okay, so deep breath. What are we going to do about it? There is hope, and in my mind, hope comes in the form of rights of nature. And how does it solve these problems? It gives nature inalienable rights, court-enforceable rights. The goal of rights of nature is not less degradation. That's the goal of our current environmental laws. The goal is thriving ecosystems, is restoring nature to health as a legal right, not as just an option. And nature has a seat at the table as well in all forms of governance under rights of nature. And we've expanded rights in the past, not that long ago, women's rights. Slavery was not that long ago. The last living slave was thought to have been alive in 1971, so it's not that long ago that was an institution. Civil rights, gay rights, and I believe rights of nature is the next great rights-based movement, and it's happening now. We've also seen the expansion of non-human rights, which we'll hear about later, animal rights, and for better or worse, corporate rights. Okay, so quickly to give you some context, so you know what I'm talking about specifically. In the Western U.S., what am I talking about? Right now, humans and corporations own water rights. What if rivers own those water rights themselves? Rivers are severely over-diverted. What if rivers had a legal right to minimum flows to be healthy? There's few conservation requirements. What if it was required for the biggest water users to use the best available technology to conserve? And what if polluted waterways were restored to health as a right? That's what we're talking about. And we'll hear about it more today, so I'll blast through this, but it's happening all over the world. The first river to have legal rights was in Ecuador, the Vilcabamba. I'm sure we'll hear about that. And then last year, legal rights were given to the Wanganui River, the Ganja and Yamuna rivers, although the Supreme Court stayed this decision. I hope they uphold it in the end. And the Atrato River in Colombia, which was severely polluted by gold mining and other sources. And we're doing rights of river work as well. We've been inspired by these victories. We've come up with a universal declaration of the rights of rivers, describes certain rights, the right to flow, the right to restoration, the right to native biodiversity, and we're using it in countries all over the world to seek new laws giving rivers legal status and protecting their rights. In Mexico City, which used to be a water city in the middle of a lake and is now completely paved over, it has one free-flowing river left, the Magdalena, and we're working to give it legal rights and got a law passed in Mexico City that includes rights of rivers. The river Ethiop in Nigeria, which magically bubbles out of a giant cottonwood tree. We're working with partners there to give it rights. Working with Boulder Rights of Nature, an amazing grassroots group to give rights to the whole watershed, the Boulder Creek watershed. Serbia, where there's over 800 hydroelectric dams planned on rivers. Indus River in Pakistan. Anchicaya River in Colombia, where we submitted an amicus brief for rights of this river, and we're submitting amicus briefs in courts throughout the world asking for rights of rivers. Okay, so that's rivers. A quick last few notes to set up the stage. Just on legal drafting. I really like to talk about when you're writing rights of nature laws or looking at the laws as the legal system is something that can be beautiful, something that can be poetic, inspiring, something that can harmonize with the rhythms of the universe, something bigger than us. And that's how I look at rights of nature, legal drafting. I really think it's an opportunity to put emotion in our connection with nature in law. So the contract students here are like, I don't know about that. Law is poetry. Sierra Club versus Morton, you may hear about more today. The Supreme Court in the U.S. somewhat almost, recognized standing for ecosystems in 1972. Justice Douglas had a beautiful dissent. We recently worked in Crestone, Colorado with an amazing rights of nature advocate, Myra Jackson, the mayor there, Mayor Danforth and others, and they wanted a resolution to start recognizing rights of nature that really embodied their connection with nature, that really embodied the social fabric of this community, and I think we did so in a really elegant way. A Vermont summer intern with us helped with this project, and it's still ongoing. Quick few drafting tips if you're working on a rights of nature law or any other law. It doesn't have to be rights of nature. Avoid terms like object, property, resource, natural resource. This just reinforces these flawed paradigms we're trying to challenge. Instead, use nature, ecosystem, entity. There's many choices, and I encourage you to inspire the movement through the language that you develop. Last point, rights of nature education is blossoming. The Earth Jurisprudence Seminar was the first law school activity I know of in 2007. We've been teaching an Earth Law course starting in 2013 here. There's an Earth Law club. We do high school mock trials. We're trying to educate students on rights of nature at all levels, including existing lawyers and judges. As a model, like 'em or hate 'em, the Federalist Society was founded only in 1982. Today, they have over 10,000 law students, 6 Supreme Court justices, past or present, including Neil Gorsuch. They also approved Kavanaugh. What if rights of nature had Supreme Court justices, lawyers at all levels, politicians on the Senate? That's what we want, and if we can build a movement, including at law schools, that's such an important piece, we can get there. Tony will talk, I think, a little more at the end. We're making a law school textbook to train the next generation of environmental lawyers on rights of nature. We have a lot of law schools committed to teaching from this book, and we want more. We want every major law school in the U.S. and internationally to teach. Finally, tying together education and law as poetry, we have legal interns always make a little statement about nature, and some of these I thought were so profound and really gives me hope for the future of the environmental movement and rights of nature particularly. Just one I want to read. Earth is a spirit of everything and a teacher to all who listen. Maybe one more. Earth law is the voice of our free-flowing rivers and natural landscapes that need protection. These are future Earth law lawyers, rights of nature lawyers, who are really inspiring and speak such profound words at such a young age. And I'm really encouraged about this and hope that many people here will join the movement as well. Thank you very much.
Well, let me thank Grant for what I hope is inspiring everyone. And let me also give a shout out, as I'm sure you're all thinking, Earth Law rocks. Linda Sheehan was our first executive director of the Earth Law Center. I want to, again, gratitude to you for getting us going. And I want to give a shout out to Darlene Lee, our current executive director. She will find an opportunity for anyone and everyone to help contribute to the development of Earth Law. And please, come and join us and help make this work. There you go. And Shelley, another board member.
Okay, so I'm up. Hello, my name is Shannon Biggs, and I'm the director of Movement Rights based in California, and I have a confession to make. I'm not a lawyer. Is it okay? I'm not a lawyer, and yet I work with this material around rights of nature and community rights and the issue around corporate rights every day for many years. And I'm really glad. I want to thank Margaret and Hannah for all the work putting this together and for inviting me to come and speak about the work on the ground with communities, because when we're talking about building a movement, we really have to talk about the people who are pushing this forward on the ground. And in the United States, this is mostly done at the community level. And yes, they need lawyers. And yes, we need all of those pieces at the local, state, and federal level. But my day often starts with a phone call from somebody I don't know. Sometimes there's tears. When they talk about something that's happening in their community, some evil force that is destroying their way of life and the ecosystem in their community upon which they depend, and they've run through the gamut of legal actions that they can take, and that they've done all the things that you're supposed to do as a good citizen using the tools the law currently provides.
I live in an area of Oklahoma where fracking has become...
We're going to get to that.
I live in an area of Oklahoma where fracking has become an institution. There are 13,000 active wells. There are 13,000, and each one of them has an injection well.
Are you following?
Since 2008, when there was 5 earthquakes in Oklahoma that were under...
I was about this commending Margaret for her behind-the-scenes technology. Don't panic.
This year,
pull the plug.
Communities will not be silenced.
Had over 5,000.
Let me see if we can. Hey, all right.
Okay. Communities will not be silenced. That's really clear.
There you go.
So in my work at Movement Rights, I work with communities in California, which is a plenty big territory, and in other states there are other advocates, CELDEF works across the country, and other people working in other states. But California is certainly a big enough territory where we've worked with communities to pass the first ordinances recognizing rights of nature in Santa Monica with Linda and others, and in Mendocino County to recognize to recognize the rights of ecosystems to not be fracked. So the other piece of my work is working with tribes across the United States, and then larger at the international level to work on building the movement. So as I sit here with everybody on this panel, we're part of the Global Alliance for the Rights of Nature, as well as many other people here that we will be speaking today about how exactly it is that we build the movement, and that comprises people from working at the community level, and lawyers, and people working at the United Nations, and people working at the national level, the state level, and the local level. But in the United States, rights of nature really starts at the grassroots level with communities facing a problem and they don't know what to do about it. And our work really, as we see it, is that we're not actually granting rights. The rights already exist. The rights for the ecosystem already exist. This is about recognizing rights that already exist. And that is also a big shift in our language and a big shift in the way we think about law. And really in my mind, when we're talking about natural law, for example, those are steadfast rules that we need to follow. Gravity, it's not just a good idea, it's the law. We're really talking about aligning human laws with the laws of nature, because right now they really are out of balance. And the idea of that there's this jar of things that are property and this jar of things that are rights holders, and that we can separate humanity from all of the things that our rights depend on, is part of this fallacy of human law that we need to fix. But the good news is we've certainly done that before. It's not an impossible task. So I want to just give you a little flavor of the organizing on the ground. And so now I'm going to actually call upon Casey Campornik, who is the leader of the Ponca Nation in Oklahoma. She sits on the tribal council and the business council, and they're, of course, facing some of the worst fracking anywhere in the country. And I'm just going to let her speak for herself. So now we can press play. Thank you so much.
I live in an area of Oklahoma where fracking has become an institution. There are 13,000 active wells there going on, and each one of them has an injection wells. Since 2008, when there was 5 earthquakes in Oklahoma that were under 1 to 1.5, we have escalated on a yearly basis until this year, in 1 year, we have had over 5,000 earthquakes.
We're not talking about, in current existing law, nature is seen as property, as a slave. As Native Americans were once not recognized, their rights were not recognized. African Americans, women, the list goes on and on. Our court of law makes mistakes all the time, and sometimes it's working just perfectly, just not for the right folks.
We're talking about using the rights of Mother Earth as a bridge to get us from this disaster that's all over the world into the future where we have clean, renewable energy, where we're assured that our children and our grandchildren will have a healthy air, healthy water, and healthy soil to grow healthy food on.
It's these companies who are killing them. Oil workers have the second highest mortality rate of anyone on earth, and they deserve better. So we don't want anybody out of jobs. We don't want things to go back with them. But we're praying that they have a just transition into renewable energies. What do we do with the oil? We keep it in the soil. And that water, the sacred water of life, is under attack from fracking and injection wells. What do you do? Fight back!
Welcome to Ponca City. So in Oklahoma, like many other states, communities are specifically forbidden from regulating or certainly banning oil and gas activities. And it has left communities feeling disempowered in order to protect themselves from the onslaught of these activities. And so the Ponca Nation, thinking not just of themselves, but also of the rest of the people in the state, became this year the first indigenous tribe in the U.S. to recognize rights of nature for their tribe in order to ban fracking and injection wells and pipelines. So they are leading and inspiring people not just on tribal nations across the U.S., where this work has a foundational grounding in, as Margaret said, we're trying to get back to a place that they've never left. And that is the story of separation that exists between human law and where we need to be. So they're really trying to knit this back together again. And so recognizing rights of nature has been a powerful piece of bringing human law back to where it needs to be. I work with communities in California, like in Sonoma, California, which many of you may have enjoyed a fine wine or two from that part of the country in Napa Valley. I think Tony's enjoying some now.
Hey, stop that.
I'm sure it's coffee. It's just coffee. But along with the...
I didn't think it was going to be this early that you were throwing me under the bus, but all right.
I leave early. I got to start early. Along with the good benefits that come from living in wine country, or certainly being part of appreciating that industry, is that pesticides, it's one of the most toxic places in the United States because of the use of pesticides. So going up against the winery industry to say no more pesticide use, no more clearing of the last remaining wetlands, no more using the water in a state where water, is so precious. It's precious everywhere, but certainly in a state where we don't have much of it to make wine, it isn't that people don't want to have a wine industry there, but they also want to be able to live there and raise their children there. And the laws currently exist on the side of this large industry of industrial agriculture. And so in order for them to move forward as a community, to be safe, to be healthy, they are looking to recognize rights of nature in law, which gives them the space to be able to say what kind of agriculture, not to say no to winery, to making wine, but how do we do it in a way that allows us to live in balance. And so this organizing and the law, this moving forward of the law, not only do we need lawyers that are going to put this work forward and open up this space, but we do so that communities can walk through it and be protected and allowed to let the law evolve. So this is about a partnership between communities and the legal community. Thank you.
Well, thank you. So panel discussions, in my experience, are most effective and interesting when there's a dynamic. And so I want anyone and everyone, as you know, we've got microphones. Let us know if you've got thought, comment, question, and we'll use that as a thread for further discussion. And as you're thinking about those questions, I'll throw one out to get us started. And what you've heard is the importance of taking responsibility, of humankind's responsibility to do what we can to bring the earth back into a balance that will be good for us. And so let me start with you, Shannon. working on the grassroots level, how widely is this responsibility acknowledged? You come into communities where there's a problem, and of course that raises people's interest. But just generally, do you think that, let's start with the United States or even California. You've told us some stories last night about the myth of California. Is this a responsibility that most people get, some people get, and what can we do to foster this responsibility?
That's an excellent question. In California, which is different certainly from other states in some respects, is that we take a great deal of pride in the environmental laws that we already have. The California Environmental Quality Act, and we have lots of lawyers who've been working on within the regulatory system on environmental issues and have had some successes. And that actually creates, in some ways, something that needs to be confronted in a way by communities, which is, and lawyers, to say that the existing structures of law are not actually getting us what we want. If our laws in California are so great, why are the people in Sonoma suffering the way they are? If the laws and environmental laws as they exist in California are so wonderful, why is fracking happening there? Why are people, being, dying who are next to the refineries? Why are all of these things happening if our laws are so great? So in California, what has been happening over the last decade that I've been doing this work is really a transformation of the idea that the existing law is not enough. And communities are facing that every day because they're having to make the decisions about whether or not they have to move to protect their children, to protect their families. So we have seen, I mean, it was really a battle, and 10 years ago, with even in the environmental law community, who really resisted this idea. But it's really beginning to open up, and people are really beginning to recognize that rights of nature is something, it's not just a crazy idea that some radical people thought of, that this is an actual movement with legs, and that as more and more law schools also begin to take this seriously, it opens the door for lawyers and therefore for communities to begin to embrace this work.
Grant, let me just, with a little twist on this, your work in Crestone built upon the community taking this responsibility. And what have you learned in terms of, again, just generating this recognition of, on a communal level, responsibility to do what we're trying to accomplish here?
Yeah, well, I have a few lessons I can give with just grassroots activism and rights of nature. A few important things, kind of the secret sauce, at least in my experience. One, connecting with a really respected local leader in any community you're working in, and this is true for rights of nature or any other movement. In my case, someone I mentioned, Myra Jackson, was a very well-respected local leader who told the community about rights of nature, and they were very interested. Another thing, you have to build trust with the community. In my case, working on trail building, getting to know their local environmental leaders and having their blessing for a campaign like this, showing up and being there and going to the local coffee shop and just getting to know people, especially in a small town. Another thing, my focus really in a local rights of nature, this was a resolution, non-binding to start, and they're moving towards something binding. My approach is that it should reflect the goals of the community. It should reflect the community's relationship with nature. It should be something powerful, and ultimately what I see it as a rights of nature law at any level, local, state, national, international, is a gift to future generations, a gift to nature, and it can be a really powerful and emotional thing for anybody to give that gift, and I think Crestone was a great example of that. Also, one other important thing, tried and true experts are extremely important. For Crestone, we had the help as one of the lead writers of the resolution of Marcia Moutrier, the former Santa Monica city attorney, who was one of the lead writers of their Rights of Nature ordinance. And so I have to recognize her efforts as well. So that was Crestone. It was, I'm really excited about their future relationship with Rights of Nature. And go visit if you haven't been. It's spectacular in Crestone, Colorado.
So Margaret, at the Berry Law School, again, I expect people there, like people at this law school, come already with at least the seed ready to germinate, the seed of responsibility. And how do you fertilize that and really help the law students wrap their head around this existential threat we're facing if we don't change the laws?
Yeah, absolutely. We have a very extensive environmental and earth law program at the school, and it does bring a lot of students there. But the good thing about being based at a law school is that we also have that opportunity to have those little one-credit intro courses for people, who may not have been involved with this type of work, or who may not know that they have that interest yet. The interest is there. So we have this opportunity to work with the students, and at least, and until you put that very well, just plant those seeds so that we have this generation of lawyers going out into the world who, you can go into any area. You can go into corporate law. You can go into, civil defense. But when you have these priorities in the back of your head and you have these concepts as something that needs to be considered as well, that's really the start of it. Not everybody is going to be a full-on earth jurisprudence or earth law advocate. But if we have a body of lawyers out there with these concepts in their minds, then we're going to start to see it permeate into the legal system. These are going to be the people who are going to be helping craft the laws. And when you have those priorities in place, we're going to start seeing them reflected. Just to touch a little bit on the way you phrased the question with Shannon, people do get it. And we know people get it. You can see that. Just look at the whole green movement as a whole. Putting something in a green bottle now is an advertising tactic, because people want to do things that are better for the environment. And we know that. Just look at, the straw bans that are popping up. We have billion-dollar corporations who don't have to do this, doing this because they know it's a reflection of what people want to see. And where did that come from? I mean, frankly, the straw bans came from a few YouTube videos of the poor turtles with the straws stuck in their noses. That sparked an entire thing where we have Starbucks, starting to make these tiny incremental changes, getting us somewhere where we want to be. So it is a reflection of seeing how these things are grassroots and how it does come from these little seed plantings and just showing people what the priorities are. The trick is then having those priorities reflected in the system and at a more systemic level. We had similar problems in Florida where if you look at the laws, that's what we're doing now at the center, is actually compiling all of our laws. So when we go and advocate to the lawmakers, we can say, look, there are all these times throughout this state's history that you have identified the environment and nature as a priority and our water. And we have this beautiful language that when you read it, we should have the clearest, most free-flowing bodies of water in the world. But we don't. They're not flowing. They're green. They're covered. There's too many nutrients. There's no flow. Why is that happening? And so that's where it comes back to we have that sort of grassroots individual priority, and it's getting that priority reflected at the systemic level.
Grant, you got to chime in here?
I just had a quick oversight in my comment. I also wanted to mention, before I forget, the importance of volunteer legal experts and legal support with Crestone. I wanted to acknowledge the support of Vermont Law School from which we had a legal intern working on Crestone over the summer that really gave Crestone the confidence to move forward on rights of nature through their legal contributions. So just wanted to mention that because I forgot to.
Stand up, Will. Cormac, you still with us? Well, I'm going to throw another question out to our panel, and I will text him. But we've talked a bit about, or heard spoken about, inherent rights. And my personal experience, if I ever walked into a courtroom and started talking about inherent rights, I would probably not get very far. It's a concept that obviously is difficult to understand, and in the context, at least of American law, doesn't really play well ever since Jefferson said these inherent unalienable rights are, et cetera. And so I think the problem in talking about inherent rights is that we all have a concept of that. We also have a very clear body of law that explains what corporate rights are. Corporations have rights. So how do we reconcile, and I'll throw it out to the whole panel, this concept of inherent rights with rights conferred by legal systems that then enforce rights? You want to take a shot at that one? Margaret?
Yeah,
Shannon?
sure, of course.
Grant? Anybody?
Yeah, so Cormac, sort of introduced this idea during his talk, so I'm going to try and not be repetitive with the short time that we have. But, as we talked about, we have to sort of rethink our idea of rights and what that looks like as we're expanding their recognition. But for purposes of us understanding it in this moment, before we've done that expansion, we can look at the systems that we already have. We can look at the concept of human rights. Decades ago, the global human community, for the most part, decided that there were basic human rights. And that, from there, once we've recognized that, we do sort of have this established body of law internationally, nationally, in various countries that stem from that we have this understanding of what human rights are. And so when we see something that we think is a violation of that, we can look to decades of work and say, okay, what you're doing is clearly a violation of human rights here. Not to say it doesn't happen. It's happening today at this very moment all around the world, even in this country, But we have this sort of settled idea that we can use to assert and defend and respect those idea of rights. So really that initial recognition is the first step. Once we say we formally adopt the Universal Declaration of the Rights of Mother Earth, for example, if we adopted that as international law, we'd have the start of something where we can start building that body of law that we can build on, and it's something that, again, it's that idea of inherent. Human rights, you don't have to do anything to get those. You don't have to earn those. You have those simply by existing as a member of this species on this planet. So the idea of the inherent rights of nature, it would be just by existing. All the other members of our Earth community have this idea of rights inherently. They don't have to earn it. It doesn't have to be commodified. There doesn't have to be some monetary benefit to human beings for them to have these rights recognized. So I'm not sure. I think I went a little off.
No, I thought that was insightful. Okay. Did you have a comment?
Always. Always.
That was a rhetorical.
So when we are working with communities to pass ordinances at the local level, rights of nature doesn't stand alone. We're also looking at the idea of community rights and saying that at the local level, people who bear the brunt of the activities of Corporation X are the ones who should be deciding what those policies are, because they're the ones directly affected. So it's also a question of directing where, human rights and who gets to make the decisions about what happens to these people. Are we really sacrifice zones for this larger these larger activities? Is the state the right place? Are the corporate boardrooms the right place? And communities are saying, no, we're the ones who should be making the decisions about this. And also, we're the ones who are recognizing the rights of ecosystems in the places where we live, because this is our community and it's our charge to take responsibility. which is, also this idea, especially in working with tribes, of indigenous rights. All of these things come into play, and they all come into play in direct confrontation with this notion of corporate rights. And what's really interesting is you take this idea of corporations, which really are legal property, and to have been granting actual property and conferring upon them these rights when you're telling communities and ecosystems that silly people, you're property. And so we have this, so it's backwards. So every movement for rights has been told that their quest to recognize their inalienable rights are laughable. And so this has been the struggle of slavery, movements, all the movements, women's rights, indigenous rights, civil rights. This has been the process. Nobody really thinks of Martin Luther King as a legal scholar, but really, when we're talking about movements, the goal is to be seen. Our rights to be recognized within the Bill of Rights, to actually be seen in the court of law as, as rights holders. So this is the ongoing struggle, is what do you do with that?
Are there a couple handheld mics? I think there are. And there's someone in the back. Why don't you kick off a question there?
Ooh, is it working?
Hey, Cormac.
Okay.
You're back.
All right. I just had a question about kind of something out of concern, just because what you guys were talking about, there was something about it that kind of bugged me, but maybe it was because I misheard or didn't get it quite right. Are you guys looking to particularly change the way we kind of look at nature through the court system or through legislation specifically? Which one? Are you trying to do both, or are you trying to more look at passing like kind of case law situations?
Thank you for pointing that out. It wasn't clear enough. And I think I can speak on behalf of the panel here. It's both. My personal experience is in courts. Grant's work in Crestone was obviously with the municipal government. Shannon's work is both on the ground developing community rights through legislation and through supporting legal actions.
Because the reason I asked was just because I'm very concerned with heavily trying to bypass the legislative process to, kind of jam something through court systems rather than take the kind of step-by-step legislative path. I'm not really a fan of expanding court powers like that if it can be avoided.
Well, it's a really important observation, and we have two legal systems. We have legislative and we have a judicial. And it's critical to understand what are the limits of both and what are the opportunities presented by both. And I think your perspective is a good one. Look hard, and if you don't see that there's an opportunity in a court of law, work through a legislative body. If you get stalemated in a legislative body, that's when you go to court. They're mutually reinforcing, of course.
Absolutely.
And I would add to that on the issue of inherent rights. If you go to a court in a country that doesn't have a ban against torture or doesn't have, a legal rule about the right to life, I think a lot of people think it's reasonable for that court to interpret, a ban against torture, a right to life, as an international norm, a customary law that supersedes the legal system of a country. And rights of nature kind of takes the same perspective. Nature has a right to life. If someone executes someone, that's pretty obvious, but is it, from a perspective of nature as a living person, is it that different what we're doing to nature? And I think, you're asking courts not necessarily to create new law, but to recognize rights that we believe exist. So that's the approach taken. Yeah.
So I have a question from...
Can I say something?
You're on. Did you have something to say?
Sorry, Tony, my sound dropped a little while ago. I just wanted to say something about this question of inherent rights. I think what's very important to appreciate is that we're talking about a dramatic transition in legal systems. So when I was a law student, I was growing up in apartheid South Africa, and there were all kinds of laws which prevented people having rights which would be normal in a democratic society. And certainly many human rights were not recognized within the country by the legal system. But the concept that there were inherent human rights was something people could aspire to. And also people got together, for example, and it was a Congress of the People, and they came up with a Freedom Charter, which was an expression of their aspirations for the kind of South Africa that they wanted to live in, where people could have peace and security in their homes and protected from arbitrary arrest, etc., etc. So the concept of justice and human rights, etc., is extremely important in achieving transformations of legal systems. And I think that in these instances, it's kind of absurd that something which only exists by virtue of a legal fiction, like a corporation. I mean, you can't see a corporation, you can't see, it's an intangible idea, that something like that can have rights and very powerful rights, when something as real as a mountain or a river doesn't have any rights. I mean, there's a kind of logical absurdity that we've got used to. But in terms of changing the society, and of course, law is in many ways like the DNA of a society. It partially determines how like the societies transform themselves and grow. It's very important to have these higher ideals of what the law should be or could be, to inform the changes in the actual laws made by the legislature or the judgments made by the courts. So I think that certainly the idea that nature has inherent rights like human rights is a very important prelude to, or a very important part of changing norms of acceptable behavior and ultimately flowing into law. So, for example, if you look at the Universal Declaration of Human Rights, that only came about because of the horrors of the Second World War, the Holocaust, etc. And then it was sufficiently shocking to the global community for them to say, look, we need to establish some basic principles here which apply right across the world. And the Universal Declaration of Human Rights is not actually a legally binding document. It's an expression of the consensus of the nations of the world as to what is appropriate norms. Of course, it has subsequently given rise to internationally binding treaties, and it's informed many laws, etc. So I think that in many instances, what we're concerned with is that process of setting up fundamentally different ideals and norms of acceptable behavior, which will ultimately feed into black letter law.
I think that Cormac's use of the word absurd is one that it has to be emphasized, and it has to be used, whether we're arguing in courts or legislators or just socially. Something that does not exist except as a legally constructed concept. A corporation can own things that do exist. Rights to water flow, rights to drill, rights to harvest timber. This disconnect is something that well thought out briefs and oral arguments can crush, and I think we'll hear later from Tom Lindsay and others on the last panel of the day how these are very persuasive arguments, and there's been a lot of progress achieving both legislatively and in courts of law, achievements made by demonstrating the absurdity of the legal concept of ownership, the legal concepts of property, the legal concepts of corporate rights. I have a question from Twitter, and I've never been able to say this before, so I'm definitely going to read it. We got a question coming in from Twitter, from JL_DeVoe. And it's a question for you, Shannon. How do you get lawyers to buy into the concept of rights of nature? Given that, as I've just explained, we can look at rights and argue very persuasively that rights conferred by courts are simply absurd.
More and more, I look over here at, Linda Sheehan, and somebody who toiled in regulatory law and at the state level. I think some lawyers come from just the experience of having beaten their head against a wall, or even those who have victories using the existing system of law, and yet the communities that hired them are still getting pummeled. And so, they're winning awards for having this great environmental track record, and they look at the communities that they defended, and those communities are being completely, screwed over. So that's part of it. And I think that was the start of it. But more and more, we are also seeing this expansion and things like this, where there's a room with students who are listening in and are, they haven't already been trained to think just one way. So I think now we just as movements, grow and people come from all these different perspectives, we're opening the door, and law schools are opening the door to these ideas, which allows students to begin to think differently about what's possible in terms of their law career. But ultimately, we still struggle in California to get enough lawyers who will take on this work in their communities. But fortunately, when a lot of times we get local lawyers from the communities who understand the issues and understand the problems and are willing to work to defend the place where they live as well. So it's an ongoing process of expansion, but I think it is something that's sort of on the verge of exploding.
Let me, for this audience, and then I'll get your question, just throw out, you as law students, as faculty, as people vested in the educational community, we teach it. That's how we get it out there. That's how we engage lawyers to understand it and advocate. So you got a microphone? Here we are.
Yes. So thanks for being here. This is really interesting to me. My question is, can you explain what some of the rights of nature are? I mean, I'm just assuming that existence is one that you've mentioned, but I don't really understand what's meant by that. I think of nature.
Cormac, why don't you take the first shot at this one, if you would?
Yes, it's a good question. So we've made an attempt to define the basic rights in the Universal Declaration of the Rights of Mother Earth. But as you say, the fundamental ones, which certainly Thomas Berry identified, was first the right to be, the right to exist, which in human terms is the right to life. He also talked about the right to have a place to be or exist, and the right to participate in the ongoing evolutionary story. In other words, play your part in the whole. And certainly that sometimes people express it as the right to flourish and evolve. And those things may sound quite abstract, but to give you, just to add, this would be seen as the minimum basis of rights. It's not regarded as an exhaustive list of rights. And the Universal Declaration of Rights of Mother Earth was obviously a negotiated document. It talks about a whole lot of other more specific rights: the right not to be polluted, the right not to be genetically manipulated, et cetera, et cetera. But I think, as Margaret has already said, there would be essentially a common basis of rights, and then there might be more species-specific or type-specific elaborations. But I mean, to give you a more practical example, in South Africa at the moment, a huge number of lions, in fact, more lions that are in the wild, are being bred in captivity. They were originally being bred for what we call canned hunting. I mean, they would be bred to be shot by trophy hunters, a lot from the US, but also countries like Germany, who would come and pay for a safari, be taken around in the bush, and then suddenly, we're very lucky there's a lion, and they shoot it. But the lion's been put there before, and it's normally been drugged, etc. And it's a tame lion. So then the US restricted imports of trophies, and now a lot of the lions are being bred for lion bones, which are sold as tiger bones in the East, which means that lions don't even have to be in good condition. Now, the reason I'm telling this story is that because lions nobody envisaged that people would farm lions. So our legislation dealing with farm animals doesn't really cater for lions. But the people who own them say, well, they're just property. So if I want to breed them for bones, that's fine. Now, obviously, though, these lions are not playing their evolutionary role. They're not in the ecosystem. They're not playing the important role that lion plays in the ecosystem. And so, if there were rights of nature, I think this would be an infringement of the rights of the lions to have a place to be and to participate in the ongoing evolution of the planet and the maintenance of the ecological integrity and health of the planet. But yes, I think that what's fair to say is that process of identifying what the fundamental rights are of nature, or different aspects of nature, would be an ongoing process. And so, for example, in relation to a river, it might include the right to flow, etc. But it's very much about maintaining your identity. What is fundamental to a lion, to a river, etc. And so the rights that one would identify are linked to the maintenance of the integrity, the existence, or the identity of that aspect of nature, and then its participation in the community of life.
Grant, did you have something to add on this point?
Yeah, I'll add a couple of quick comments. It can be confusing to define exactly what rights nature has. As Cormac mentioned, the Universal Declaration of the Rights of Mother Earth has some of those fundamental rights. Also, various laws and treaties regarding rights of rivers and court decisions also describe some of those rights. My approach, considering that rights of nature is an evolving field, that there's politics intertwined with it, and that it's different in every country in the world because it really depends on context. My approach is to really focus on the most egregious rights violations. A river that has a right to exist. If the river is under 10 layers of concrete in a city, that's a pretty clear rights violation of that river or its right to flow. A river that's completely dead, that's a pretty clear violation of what is, I think everyone would agree, is a right to exist or a right to life for a river. So my approach is, focus on the very egregious, clear cases. Meanwhile, I hope that more courts will hear rights of nature cases, and that there'll even be rights of nature courts set up that can, work on some of the more difficult issues. I think by the time, we get to the smaller scale and the more minutia, the courts will have helped figure out a lot of this. But I like to focus on the easy ones first because it is complicated.
So we're winding toward the end of our time, and I'd like to give all of our panelists an opportunity to make some closing remarks. Should we start with you, Margaret?
So thank you again for having us here. I think that these conversations are very important because we are developing this body of law at the moment. And so these questions that come up are very important. And I think that as we gather the people who are going to be developing these bodies of law going forward, we're going to start to understand them better. At the center, we like to use the phrase that everything has a right to live out its evolutionary purpose. Some members of our Earth community, their purpose is to exist, and so they have that right. And then it is at the end of their life to be consumed or to be used, as nourishment for another member of the Earth community, or to be utilized as a craft in some way. And so once we understand how the ecosystem works together, we'll have a better understanding of what those rights are and what they look like and how we can respect them going forward.
Shannon?
Just to weave in some of the last questions, I think in terms of defining rights of nature, Indigenous people look at a 7 generations approach, looking, 7 generations ahead. Their rights and opportunities should be the same as they are now. And I think we have Hugo Echeverria from Ecuador, who will speak to the Ecuadorian constitutional process and really define what that looks like in terms of the right to exist, to flourish and evolve natural cycles, which as a community organizers is what sometimes we call the duh principle, for lack of a better legal term. terminology. And I think, as we'll hear from Thomas Lindsay later, also that in terms of the question on legislative approaches, this organizing at the community level isn't just about recognizing these rights in that local community. It's how do we actually drive this forward into, at the state level and the national level. It comes from the grassroots level. It's growing in states where this work has been done, and CELDA certainly pioneered that work in other states. There are a significant number of communities who have passed these laws, and they are now working on state constitutional changes to recognize these rights and enshrine them in those, in those constitutions to provide the protections that communities need in order to move this work forward. So it really is not just it's not just about the courts, it's not just about the lawyers, it's not just about the communities, it's not just about the legislature, it's all of it. This is about how does a movement grow and work together, and how do we come together to move this work forward, and also work with our partners internationally and Indigenous people who've been holding a lot of the space about what does it look like to understand at the local level, what does the balance look like? How do we get there? How do we drive that work forward? So it's about respecting what each part of that movement has to offer to be able to come together, and just like working in any coalition, as they say, if you're not uncomfortable, you're not working with enough partners. So, so part of this, work moving forward and growing movements is this uncomfortableness of saying we don't have all the answers. We're all trying to figure it out as we move ahead with a very clear vision.
Grant?
Yeah, a few closing remarks. One, I encourage everyone to join the movement. Anyone can do it. There's a beautiful river right out the door there that would be very happy to have legal rights, for example. If you don't want to join the movement, consider integrating rights of nature to some extent into your work, whether it's something small like changing the language you use, or something bigger like including rights of nature in a memorandum you're writing about rivers as a footnote at the very least. If you don't believe in the movement, join the conversation still, because it's really important, as Shannon talked about, to challenge yourself, challenge the viewpoints, and have a large coalition. My goal is always to convince the biggest skeptic that there's value in this movement, whether it's someone who is a far-right Republican who might not traditionally believe in rights of nature, to connect on common values of, believing in the importance of living in a healthy community and the value of family and a good life. Someone on the radio I heard talking about the Black Lives Matters movement made a really good point about activism, which is it's really important to not just say no, because if you say no, you can only be as big as that which you're saying no to, but to say yes, because if you say yes to something new, then you can be even bigger. And I think that's very true with the rights of nature movement. And most of all, I'm very encouraged about all the people working in this field, especially students, and excited to see what the future holds. I'm very optimistic.
Mr. Cullinan? Cormac? Can you hear me?
Sorry, I didn't hear you. Thanks. Yes, I just wanted to make two closing points. The one is the main reason for asserting rights of nature is to create the correlative duties on human beings. So you can say to the river, I recognize your right to flow. The river doesn't need to know that. The river knows how to flow. But the real issue is that if the river's got a right to flow, then there's a corresponding duty on human beings to respect that flow, and that one can enter into a balancing exercise if there's a conflict between human rights or interests and the river's rights. There's a balancing exercise that can happen. Instead of humans automatically trumping the rights of the whole of any other aspect of nature, you can actually begin to use the law to promote ecological balance, which is what we really need. So in many ways, although we talk about rights, it's really a way of creating the duties on humans. The other thing to add on to what Grant said, I mean, I think we're in a law school and we're talking about the basic legal concepts, but this is embedded in a huge global movement which is growing day by day. And this is something which is more significant and bigger and than the human rights, than the rights movements of the past. It's bigger than the civil rights movement, bigger than the struggle against apartheid. And I think it's an incredibly important movement. And if it succeeds, it will transform society even more than the concept of human rights has transformed global society. So I really hope that many of you will be inspired to enjoy the movement and contribute in some way, whether through writings or actions or activism, because I think it's an extremely important movement and it's extremely exciting, and it really is a game-changing, world-changing movement and strategy.
So let me wrap this up by saying that we've focused on this term, rights of nature. And rights of nature is a very important thread in this tapestry of Earth law. What we'll hear later today some more about are rights of future generations, the wisdom of elders and indigeneity, public trust doctrine, animal rights, guardianship, these legal legacies that we've touched on of the civil rights movement, of women's suffrage, of course, human rights, of cultural diversity. These are all threads, and find a thread and start pulling it, and it just will lead to wonder and opportunity. And again, as much as anything, we're here to just recruit young people, old people, anyone who's willing to put their mind to this matter. So thank you very much.